Thank you. Before I commence, I actually want to acknowledge and thank Associate Professor Bronwyn Naylor. She's my supervisor extraordinaire. And she's had a lot to put up with, I think, with me. Firstly, though, I want to acknowledge the Wurundjeri people of the Kulin Nation, who are the traditional custodians of the land, and to pay respect to the elders past and present of the Kulin Nation and extend respect to other Aboriginal people here today. I want to thank too the Castan Centre for inviting me to speak today. It is an honour, and an honour indeed to be in the same session as Megan. I've been asked to address, I better get my, nope, we'll stay with that one for now. I've been asked to address whether or not the Victorian Inquiry and the recently established National Royal Commission into Child Abuse will deliver justice to victims and their families. Firstly though, many ask me why I'm actually doing this work. Not long after I completed my honours thesis in law in 2006, and as Bronwyn said, I was looking at appeals against convictions of child sexual assault generally, not just clergy. A close family member of mine disclosed to me that he had been anally raped on many occasions by a Christian brother when he was 11 years of age at school. I followed his journey over the next few years and started to familiarise myself with the civil law in particular in this area. It didn't take long for me to realise that there were multiple legal barriers facing victims of clergy abuse. I also learnt about the Towards Healing process while speaking to lawyers and many victims and survivors and their families, as well as my nephew. He went to Towards Healing and they basically said, "We don't believe you, go away." A couple of years later, his offender ended up pleading guilty in court, and that was a couple of years ago. So anyway, it soon became clear to me that not only was justice unattainable for these people, they actually faced further abuse and trauma. So this is when, about 3 years ago, I decided to take on this research. I'm going to just read a quote to you from a male survivor whom I interviewed for the research. He was brutally assaulted, physically assaulted and brutally raped when he was 11 and 12 by a Catholic brother also. And maybe this quote will help enlighten why I decided to do the research. He said to me, "I spent all that time in fear. I had nightmares at night. I used to go to bed at night and try and hold my breath so I wouldn't wake up anymore." So this takes us now to what is my research. I basically wanted to examine whether or not victims of Catholic clergy sexual assault were finding justice. To do this, I focused on which pathways victims had been down or were going down to find some justice. Two such pathways, and there were more, were the criminal jurisdiction, so prosecutions and convictions of the accused, and importantly the civil jurisdiction, so suing either the church or diocese, or in fact a religious order or the offender. So to gather the data, I interviewed about 70 people from Victoria and New South Wales. They consisted of primary victims. Now, when I use the word victim, I'm not using that in the pejorative sense at all. It's the language in the criminal law, unfortunately, but I can equally say survivor. So primary victims and survivors, secondary victims, so family members, partners and loved ones, legal professionals, and that comprised of, solicitors, prosecutors, civil and criminal barristers and county court judges. And also a group of what I've called non-legal advocates, so advocates who basically support victims but are not lawyers. So what I want to do now is very briefly outline some of the inherent problems with both the criminal pathway and the civil pathway. In relation to the criminal jurisdiction, it's pretty well established that convictions for child sexual assaults across the board are low, and the successful appeal rates are very high. Of those who report their child sex crimes to the police, there will be about a 6% conviction rate. Earlier research of mine, the honours thesis, I found that about 55% of these convictions are appealed, and that's a very high appeal rate compared to other crimes which sit around 12%, 8%, maybe 20%. And more than half of those appeals are successful. So combining that with what we term secondary legal trauma of a victim going through a trial and cross-examination, there is overall really not much other than disincentive for victims of child sexual assault to choose the criminal pathway to find justice. With the second pathway, the civil pathway, several impediments exist. Firstly, just a brief look at the Statute of Limitations. One of the very well recognised and inherent problems with child sexual assault is that victims typically don't report those crimes for decades, if ever. And this fact is not reflected or not catered for in these particular statutes. So the first hurdle for the survivor would be to apply to the courts for an extension of time in which to hear the case. So that's hurdle number one. Problems exist too if one is trying to sue, for example, a bishop or an archbishop. Because of the delay with reporting, the bishop at the time is often either dead or perhaps in a nursing home. But because the incumbent bishop is not what we call a corporation sole, he cannot be held liable for any of the wrongs of his predecessor, such as, for example, concealing the crimes or covering up the crimes of the accused. So another barrier. Thirdly, the law of vicarious liability, which is a very old legal doctrine where an employer can be held liable, albeit vicariously, for the negligence or wrongs of the employee. Australia's conservative approach with this doctrine contrasts quite sharply with the recent advancements in the UK in particular, but also Canada, where Catholic archdioceses have been held vicariously liable for the sexual assaults on children by its priests. The last and probably the most controversial impediment here in Australia relates to what is commonly called the Ellis Defense. Basically, in this 2007 New South Wales Court of Appeal case, Ellis, who was the victim or the plaintiff, tried to sue, amongst others, the Sydney Archdiocese Property Trust. Now that's a trust that holds and manages the assets and property of the Sydney Archdiocese. To cut a long story short, the church successfully argued that the property trust was not the right entity to sue. Basically, the trustees were not responsible for the behaviour of the priests. But because there's no other legal entity for the church to sue for these mostly now historical crimes, it means victims are once again stymied. Or another way of looking at this is the Catholic Church is effectively immune from suit for these types of crimes. So coming back to my research on this point, I'm going to have a bit of a look at what the lawyers that I interviewed are doing for victims in relation to litigation and financial compensation. Firstly, apart from one matter in the late 1990s, which was a class action that went all the way to the High Court and failed, not one other Catholic matter has ever reached adjudication or verdict in the courts. So one matter only, and that ended up having to be negotiated anyway because it failed. Half of the lawyers never issue proceedings at all. That is, lodging writs, for example, in the courts. About a third issue proceedings very, very occasionally. Interestingly though, regardless of whether proceedings are issued or not, it is only this one case in the 90s that has gone to adjudication or verdict. Basically, this is due to this Ellis Defense. Tellingly, the 12 lawyers I interviewed, between them have represented around 2,200 clients or victims of clergy abuse. This means at a national level there are possibly tens of thousands, in my reckoning, of clergy victims who do not have equal access or access to the courts, the civil courts. A clear breach, obviously, of a very fundamental human right. So, in summary, victims of Catholic clergy sexual abuse are severely limited or hamstrung if they want to find justice in either the criminal and or the civil courts. So, with these sort of legal dead ends, where are victims and survivors going to try and find some compensation or justice? And this takes us on to what are the two internal Catholic Church complaints processes, Melbourne Response and Towards Healing. Melbourne Response was set up by now Cardinal George Pell when he was Archbishop of Melbourne back in 1996. And that covers just the Melbourne Archdiocese. Why that needs to be the case when the rest of the country is covered by Towards Healing, we can only surmise, I suppose. But Towards Healing does deal with the rest of the country. Nearly half of the primary victims that I interviewed had been through the Melbourne Response, and a bit over a third the Towards Healing process. Under a fifth had not been through either process. Now, these numbers certainly would not reflect or represent the national or even the Victorian picture here, as the majority of the interviews and the research were from Melbourne. But you're not going to get that sort of breakdown nationally. Now, there are multiple problems with both these processes. I'm not going to go into them all, but broadly, fundamentally, the Catholic Church is investigating sex crimes of its own clergy, the very crimes it had attempted to cover up for decades. Also, no organisation should be investigating itself. So, put simply, sex crimes are matters for the police and the state, full stop really. Secondly, the Church claims that the processes, their processes and their personnel are independent of the Church. This is not the case. All personnel for both processes are appointed by the hierarchy of the Church, and both processes are fully designed and paid for by the Church. Importantly too, they're certainly not seen to be independent. Basically, there's no transparency of process or implementation of process. Towards Healing does publish a protocol or a set of processes, but other than that, there's no transparency. Both processes claim that they offer a pastoral, informal, compassionate and victim-focused approach. This isn't the case at all. They are unarguably legalistic and adversarial. QCs and legal firms sit at the core of these processes. And on this point, my research also shows that the majority of the lawyers interviewed found the Catholic Church, compared with other religious and non-religious organisations, to be much more legalistic, adversarial. They made it harder for the victims and survivors. They made smaller offers, and they were more hostile and arrogant. In relation to legal representation of the victims going through these processes, the research also shows that there is often a policy at Melbourne Response and Towards Healing of them actively lobbying victims to not have legal representation. The story is, you don't need a lawyer, don't worry about it. Basically, the victims were at a disadvantage due to marked power discrepancies. So mostly victims cannot negotiate effectively and on an equal footing with the legalistic church authorities. They're also severely disadvantaged in terms of financial compensation. One lawyer who refuses to work with either process, and he has represented between 500 and 600 clients himself, says that his clients receive amounts that are about 10 times those of Towards Healing and Melbourne Response. Also with these processes, whether compensation is to be paid at all and how much is completely discretionary. That is, every bishop or archbishop, every head of Australia's roughly 140 religious orders has absolute and individual discretion as to whether, firstly, compensation is to be paid, and secondly, what that amount might be. This means there's no consistency and there are also no guidelines. So discrepancies, in fact, are prevalent. It's the same with the Melbourne Response, which hasn't published any processes or guidelines in relation to the workings of its compensation panel. Also, there is no external independent review and there's no appeal for either process. So the overall experiences of victims and survivors who have been through these processes are pretty horrific and wrenching. I have to note too that importantly, the victims' evidence in this research is very, very firmly buttressed or supported by the evidence from the legal professionals, whom, as I said before, have represented over 2,200 clients, victims. Primary and secondary victims describe their experiences going through these processes. They say they were frightened, scared, it's like a nightmare, they're embarrassed, humiliated, degraded. They often say it is as bad or worse than the original abuse and often more ongoing due to the delays of the process. They feel interrogated and misunderstood by the professionals they see, and often those professionals represent the same male authority figure of the church who in fact protected the offenders. One described Melbourne Response as corrupt and swindling victims. The lawyers said one man with 200 clients didn't know of one client of his, who had had a good Towards Healing experience. Melbourne Response was described by another lawyer as a response to meet the political or organisational needs of the Melbourne Archdiocese and to some extent even the abusers rather than the victims. And another, Towards Healing is a sham and a kangaroo court. One male survivor of the Towards Healing experience, and he's a survivor of the abuse, the original abuse, and a survivor of the Towards Healing experience, said, "I was getting close to getting a car and driving it through the gates of St Pat's School and smashing into the school with my car and killing myself." That's how he felt after going through the Towards Healing experience. Another said, "It's not towards healing, it actually takes you towards madness." And of the Melbourne Response, a female survivor said, "Once they know they've destroyed the mind, then they hit them with a sledgehammer. Then they give them a pittance. Go away, nothing. And if a victim suicides, good, we don't have to pay the compensation. They don't give a damn about the dead victim." This takes us to the next and a quite disturbing topic really that I want to talk about, but it's of paramount importance, and that's the suicides and premature deaths of victims. That's not fair. I'll talk about this and then I'll go towards the conclusion. I interviewed primary victims and what I call secondary victims, and of these secondary victims that I interviewed, more than half of the primary victims associated with them, so the victim who had been abused, more than half had either suicided or died prematurely in the years following Catholic clergy assaults. Some of these deaths were boys who had been sexually assaulted by one of two alleged offenders in what's called the Gardenvale parish south of Melbourne. There were also up to 8 other suicides or attempted suicides reported from that parish. The alleged offender, for the majority of these, had fled to the UK and died before being prosecuted. We also have the shocking number of suicides, 40 plus, from 2 serial pedophiles from schools in Ballarat and other areas. So those numbers are associated with 3 or 4. I think we have 269, I think it is, offenders in Victoria alone. So clearly this issue is calling out for much more research. Now, there is no causal connection between the clergy sex crimes and the suicides, but there is one constant, and that is those who have killed themselves or died prematurely, and usually from drugs or alcohol, they've all reported, or there is a suspected history of clergy sexual abuse. So it's this connection, this common thread, that requires urgent attention. I'll summarise. I was going to take you to a few minutes. Thank you. With my research, so the central question for today is whether or not the Victorian Inquiry and Royal Commission are delivering justice or helping to deliver justice. And for that to happen, I think both of those inquiries need to address these criteria. There's around about 8 criteria or elements for justice. First, the one I want to talk about is, and I'll come back to that other slide in a moment, is accountability of the church and the hierarchy. There are many ways in which the powerful and wealthy church and the hierarchy can be held accountable, but the most pivotal form of accountability actually is prosecutions of members of the church who have concealed or covered up these crimes. To date in Australia, and we're in 2013, there's not been one conviction of a church member for this crime, not one. We've got a couple of charges being laid at the moment in New South Wales, but in 2013 it's hard to believe that there isn't one member of the hierarchy who's been convicted of this crime. There are other, obviously, important elements which I won't go into at the moment, such as mandatory reporting and so on and so forth. There's also accountability of the offenders, and just very briefly, there isn't much. Laicization of priests, in case those of you who are not sure, laicization involves a priest losing his clerical state. And that's important because it takes the status away from that priest. From the research that I did and the people I interviewed, only 3% of the offenders or alleged offenders had been laicized, and the conviction rate was 9%, which is actually a bit higher than the state average of 6%, but I think that reflected the people that wanted to be involved in the research. There were other criteria which I'll leave, but I want to come back to this graph here. As you can all see, accountability of CC, that's accountability of the Catholic Church and the hierarchy, was by far the most important. More important for all of these interviewees than accountability of the offender. So basically this element of justice or requirement of justice, as I said, involved more than twice the number of suggestions compared with accountability of the offender, and about 40% more than financial compensation. So what is this telling us? What's it saying? The members of the hierarchy, by not reporting known offenders to the police and moving them into innocent parishes and schools, are also responsible for the subsequent offending. That is, any further sex crimes were basically fostered or facilitated by the bishops and archbishops of the time. This worldwide policy of covering up actually stems from the Vatican. The original sex crimes were one thing, but the subsequent denials from the hierarchy, the imposed silence, the lies, not believing victims, and the serious abuse of victims by the Church's internal complaints processes have all contributed to what is commonly called secondary abuse of the Church. But I don't think it's secondary. I think this is not secondary abuse. It is a whole fresh round of primary abuse. As such, accountability of the Church, as shown in the research, reflects what is a criminal and stark culpability of the Church and its hierarchy in these matters. I'll just go to my concluding comments. And I thought with that, a lot of heaviness there, we need a pretty picture. And by the way, it's a sunrise, it's not a sunset. We have some hope. So just to finish off, the Victorian Inquiry has completed hearings and is currently writing up its report. The Royal Commission is still to commence public hearings and will be gathering evidence nationally on these issues. But in short, both of these bodies will need to address those earlier criteria if justice is to be delivered. Victims and their families and the nation are relying heavily on both of these bodies and the recommendations they make. But recommendations will just be half the job done. It will be then up to the governments of the day, federal and state, to act on and implement those recommendations. Victims and survivors and their families have in many ways already triumphed by having a Royal Commission and an inquiry. It is their extraordinary courage, their stoicism, their dignity, and their very big hearts that have brought about the Victorian Inquiry, the New South Wales Inquiry, which I've neglected to mention, and the Royal Commission. It's now going to be up to all of us to keep fighting, to keep putting pressure on governments to do what is really their fundamental duty. As I wrote in an opinion piece in the Canberra Times recently, it is for governments the world over to excise themselves from politically and economically from the burly hip of the church. Governments must stand up to the church, just as our Australian government has done with its Royal Commission, and breathe new life into the requisite secular laws that will bring about criminal prosecutions and accountability of the guilty ones. Thank you. Leave it up there.